child or son, daughter, however. All right, we'll try to remember that too. This case is 2023 P0538, Department of Children and Families versus Mother. How are we, is it still 7.5 and 7.5 minute split?
No.
All right, and I take it, Attorney Penta, you're going to be arguing first.
Correct.
Okay, so at least I have the basic ground rules correct in front of me. We're ready whenever, and you are representing the father.
I am, that's correct.
Perfect.
That's
All
my
right.
introduction, so may it please.
So we're ready whenever you are.
Thank you, Your Honor. May it please the court, I'm Michael Penter, and I represent the appellant father. We do raise two substantial arguments that require reversal in this case. The first, I just want to quote the judge's remarks made in the midst of this case, that I think I've said this many times, this is not really a triable case. It's not a case that should be getting tried. That is just one of a series of comments that the judge made during the course of this trial that demonstrated her prejudice and prejudgment of this case.
Right, that comment, I'm not saying you misread a portion of the transcript, but we know the DCF, and we've read the transcripts, that those are not, we really can't, in order to be fair, take comments out of context.
I agree, Your Honor. I don't think those comments are made out of context. I think
All right, so which page of the transcript are you looking at?
591 and 590, well, I believe it's at 591 of the transcript.
Let's look at that then. All right, appendix, which volume of the appendix, 591? Is it volume 2? Can you help me with which volume of the appendix you're looking at?
Yes, if you give me a second. It should be identified as the transcript.
Or is it the transcript? Okay, I see, sorry.
Maybe volume 3 if it's separately volumed, but I believe it's
Yep, it's 591. I'm with you.
Okay.
All right, so there's, most of that page is commentary by the judge. Do you have it in front of you?
I have what I apologize, I do not have the transcript, but I have what was said that I'm quoting from.
So the judge is talking about, the judge is talking about, I think it was father's request, or at least, or mother's, I don't remember, for continuance. And the whole first part of the judge's comments relate to her frustration about the continuance. And then she gets, she does say, this is also something that you all, I think I've said many times, this is not a, really a triable case. No, it's not a case that should be getting tried. It's every day the same thing. So first of all, she corrects her statement immediately, the statement you're focusing on, or at least modifies it. And she just alerting you, I think, counsel, to perhaps what she thinks parties should be focusing on. Is that not a permissible reading of what the judge said here?
I think we can agree to disagree that I think the judge's comments are a glimpse of what she had already decided at that point. I guess I can't, it's her words. I think I've said this many times, so it's not the first time she has said this. This is not a really triable case. And so it prompted
that could very well be a reflection of the evidence.
Well, the evidence hasn't concluded at that point.
Sure, but she's heard quite a bit.
But she was also commenting at that time on the credibility of witnesses who haven't yet to testify at that point. So it's a glimpse of either this trial is a charade, and it's a way, I mean, I might point out that this case had been previously tried and then vacated because of due process violations that she had no choice but to vacate because an officer of the court told the parties not to come to court. So this case had been tried before. We'll give credit to the judge for acknowledging that there was a prior due process violation in this case, but the prior due process violation continued by her own very words. I mean, I think it was Dr. Maya Angelou who said, when someone tells you who they are, believe them the first time. And I think that that kind of apropos to this case, that the judge had already decided this case prior to the conclusion of the evidence being done. And it's reflected that a number of her comments that are made are reflected in her findings of facts and conclusions of law based on the credibility determinations that for example, father's testimony.
Can I ask you a basic question?
Of course.
Can a judge decide the credibility of witness after the witness testifies, but before the trial is over?
I would probably counsel against them acknowledging that, but yes, of course, because their testimony has concluded at that time, but that's not the case here. Father's testimony, especially specifically on the issue of his substance use and treatment, hadn't happened until September. These comments were made in August and July and May. So when those comments are made prior to the conclusion of the testimony being delivered, it's clear, I'm not saying clearly, but it's certainly, to me, it's certainly a reflection of those comments being a reflection of where the judge...
Had she said, this does not appear to be a triable case, of course, I'll keep an open mind until I hear all the testimony, would that be a problem?
That's not what she said. And so I don't want to
speculate. I'm sorry, what was the answer?
I'm saying I don't want to speculate as to whether that would be or not, because that's not what she said. But if she did say...
Judge Milkey is asking you a hypothetical question.
The hypothetical question is it appropriate for a judge to give insight into what the test... Of course. I think that wouldn't have been... I would still take issue with it, but I think that's not a definitive, conclusory statement. If a judge says, I'm open-minded, but I'm not, and it probably happens all the time. I think it even happened in this case, saying, you know what, I'm not, you might want to, I think it was a mother was testifying, you might want to change your tone or attitude when she was testifying because I'm not finding you to be credible. I mean, I don't think that is beyond the purview of what a judge can do when conducting the course of their trial. But to definitively make a statement that says, why are we even trying this case? It left the impression to one of the litigants to do a belated objection because of the way she felt about those comments. So we do have a glimpse as to how the parties reacted to that comment.
You don't raise any argument that that any of the judge's factual findings is clearly erroneous.
I do raise that her findings are stale, and the issue of domestic
violence. Well, that she
violence.
relied on stale evidence, but you don't find that you don't argue that any finding is clearly erroneous. In other words, not supported by the evidence at all.
Well, because, well, again, I do argue that there are findings on substantial issues of parental unfitness, namely domestic violence and criminal history are stale. They are isolated incidents that happened years before the child was even born, much less during the child's life. I understand you argue that she shouldn't have relied on that evidence because it was stale, Right.
but she doesn't, that their findings are not clearly erroneous regarding it, correct? There was evidence to that effect.
She made a number of findings as to when the child was born, what was, I mean, these findings are supported by the record,
evidence.
but are they reflective of current parental unfitness? And that's the standard. It's not whether you are past unfitness or whether there's incidents in your past that we're going to hold against you. I mean, my client did go to jail. That's an undisputed fact. He paid his debt to society. He did deal narcotics. That's an undisputed fact. It happened in 2015, 5 or 6 years before this child was born. And he demonstrated on his testimony his regret to those incidents of that one singular incident of domestic violence into what resulted in his incarceration.
We're going to have to leave it there because your time has expired unless there are other questions.
Then
All right, I don't see any. Thank you very much.
Good
Is
morning,
it
Your Honors.
Attorney Grantham?
Yes, Grantham O'Brien.
Oh, sorry. Sorry, I didn't see the second line.
Attorney O'Brien on behalf of Mother. Your Honors, I think in this case, fairness and fact was not enough. And I know that we've talked my brother has talked about the comment about this not being a triable case. I think it's really important to recognize that the trial judge is telling the parents who are sitting there in court, this isn't a triable case. I'm not sure why we're here. This is a waste of my time. Just go ahead and exchange your parental rights for open adoption. Her comments were such that mother's trial counsel told the judge, my client yesterday was very hurt and devastated by what you said in your comments yesterday. And her attempt to cure her statements was, I'm sorry that your client heard it that way. In a sense, that's almost like saying, you know, before I say an offensive comment or a statement to you, I'm going to say no offense. And that is going to just fix it. And that's not what happens here. The appearance of fairness is just as important as fairness.
Now,
A
you
parent
said,
should-
yes, I understand all that. You said that the judge said, you're wasting my time. I didn't see that in the transcript. Can you point to me where that was said?
It wasn't said, but I think it was implied by saying that this is not a triable case. Yes, trials for these
But,
child welfare.
She did correct it right after that phrase. She said that, no, it's not a case that should be getting tried.
But I don't know if that's correction at all, actually. By saying it's not a triable case and then saying this is not a case that should be tried, that's the same thing.
All right, let's assume that it is the same thing. Would you acknowledge that there are some cases where, from the party's perspective, the case should not be tried?
Maybe from the party's perspective, but from an
And maybe
impartial
the
juror-
judge is trying to alert them to something.
Well, possibly, but before she's heard the testimony, she also said this is an opioid case. How does she know this at this point? The substance abuse, the evidence of mother's substance abuse was from 2 years prior, from when the child had been born substance exposed, but there was no evidence elicited, excuse me, in testimony that mother had a current substance use disorder. It was that she hadn't engaged in substance abuse treatment, which is what DCF had wanted her to do. Granted, she probably should have engaged in that substance abuse treatment, but there was no evidence that any of the visits had to be canceled because mother or father was under the influence of any substances. There was no evidence that there had been any negative drug screens. So I'm not sure how the judge came up with this whole case is about opioids and.
Was it incorrect on August 25th when she said they did not do treatment and the testimony all relates to my having to believe, et cetera, that these people were able to just get sober without interventions? There had already been evidence of that, correct?
I'm sorry, could you repeat that?
Sure. It's page 11 of one of the briefs. Says they did not do treatment, and the testimony all relates to my having to believe that even though the country struggles with an opioid pandemic, that these people were able to just get sober without interventions. That was the contention of mom and dad. There had been evidence of that, correct?
Correct, but if that's the case, then why does she believe that this is a substance use treatment, sorry, a substance abuse case, if she believed mother and father had been able to get sober without having treatment? I think as we know, these cases are about the best interest of the child. That is 100%, the child is paramount here. But that does not mean that the parent's constitutional and due process rights take a back seat. They don't. And a parent or litigant, any litigant, should be able to walk out of a courthouse, especially in these kind of cases where we're talking about literally breaking the bonds of a family permanently. Litigants should feel that they are being heard and the evidence is being fairly weighed, and walk out of that courthouse feeling like they had a fair trial. And here we know from the motion to recuse and mother's trial attorney's statements to the judge, that his client didn't feel that way, that my client didn't feel that way. And that
What is
appearance
your
of fairness-
best case?
I'm sorry?
What is your best case in terms of similar facts where a judgment was reversed on due process grounds? Your best case on close facts.
So this is part of the problem, is that we don't have a strong body of law when it comes to these kind of issues, when it comes to the prejudgment of cases and/or curative statements.
Is there a requirement of a showing of prejudice of some sort?
I don't have an answer for you on that. But I think that if this court were to grant mother a new trial, I would request, or mother requests, that the case be published with some kind of instructions as to what exactly might be prejudgment of a case, or what a curative statement might look like.
Why would a complete retrial be necessary? We have fully a trial transcript here. There was a full trial. There's no argument made that any of the findings are clearly erroneous, or that the evidence was incorrectly weighed, or that the evidence was insufficient to find unfitness, present and continuing. So why do you get a do-over in these circumstances?
I think that when a litigant's due process rights, and in this case, having a fair and impartial judge, are not upheld, that they should have that opportunity. Your Honor, I see my time has expired.
Let me see if there are any further questions.
Thank you, Your Honors.
Thank you. Is it Attorney Kernan?
Yes, Your Honor. Jennifer Kernan for the Department of Children and Families. Your Honor, just picking up where my sister left off in terms of Your Honor's question about prejudice, I just want to draw the court's attention to care and protection of Doretta. I believe it was that case, quoting Adoption of Mary, that said, due process requires that parents have an opportunity to effectively rebut the adverse allegations concerning child rearing capabilities. And here, as Your Honor noted, there's no allegation that parents were denied the right to present any evidence to rebut the department's allegations.
But you would not argue that due process doesn't also incorporate a requirement that the fact finder be fair and impartial?
Yes, that is a part of it. And here, this fact finder was fair and impartial. With Your Honor's first question, you noted that the statements presented by the appellants were taken out of context. And I think we have over 1,100 pages of transcript, and the comments that were culled from that came from, I think, maybe 5 or 6 pages out of those 1,100. And within those 1,100 pages of transcript, there were numerous indications of the judge overruling department's objections, siding with father and mother's counsel. One instance in particular is when father's counsel was questioning the social worker about visits and started to go through every single visit. The department at that point asked the judge to sort of limit the father's questioning, and the judge said, no, I'm not going to do that. Father's response in part was that the questions were important to establish reasonable efforts. And the court acknowledged that and agreed, yes, reasonable efforts are an important part of consideration in terms of termination of parental rights. And that's just one example of when the court sided with father's counsel on that.
When father counsel asked the judge to recuse, the judge's response in refusing says, I listened to the testimony that I did not find credible at all. So she's already made a determination of credibility before the case is over. Pretty clear. Is that permissible? If it was a juror, we'd say, we instruct them not to do that. So it's okay for a judge to do it?
I think the comments certainly were not ideal. However, at this point, and this is page 592 of the transcript that we were looking at earlier, mother's testimony started on page 336, I believe. So at this point, the judge had heard from mother. And if reviewing that transcript of mother's testimony, there's at least one point where the judge sort of interrupts and points out the fact that mother seems to be having a lot of trouble remembering questions that are being asked. I think at that point they were being asked by the department's counsel. Mother's counsel offered to take a moment to consult with her, and the judge declined, but there were at least 2 points where the judge indicated that mother was having trouble remembering it. She reminded mother that she was under oath. So I think, given that situation, that it is permissible that the court sort of question mother's credibility at that point when she has already listened to at least 200 pages of testimony.
I guess I'm focusing on, without the evidence being finished, I did not find credible at all. She's not telling mom to focus in on testimony. She is saying in that statement, I think a fair reading is, I didn't find that witness credible. And I guess I'm asking you, is that okay when the trial is not over and all the witnesses haven't been heard? For all that judge knew, there was a witness that was coming forward that was going to make it a consistent statement. She's already prejudged it, hasn't she?
I don't agree with that. I think credibility encompasses, or credibility determination encompasses a number of things. And one of the reasons why the standard is abuse of discretion here is because it's the judge who sits and hears the testimony, can visually see the witness, and that is part of what may go into credibility determination here. And I would argue that that is a significant factor here. This judge had seen mother's testimony, had heard mother's testimony,
How do you interpret the characterization of this as not being a triable case? What could that mean other than they're not going to win?
I think that it could mean that the issues are narrow in this circumstance. And this is what a lot of the discussion back and forth between the judge's attempts to sort of narrow the scope, limit the repetitive, the cumulative evidence. That's where a lot of her comments like these come from, the back and forth between counsel about narrowing the scope and sort of achieving permanency as quickly as we can. That this is part... Before the judge made the comments about this not being a triable case, the judge had sort of reiterated her view of the evidence at that point. And this was early on. I believe this was earlier on in the transcript, where there was an exchange between the judge and the father, and the judge was saying this is a narrow issue. The issue is not necessarily whether they did well at visitation. That was not it. The department was not alleging that there was any issue with visitation. Similarly, the judge also indicated that her view was that it's fairly narrow in scope, that the issue is whether parents did or did not engage in treatment. And at that point, and these comments were made before the 5th day of trial, which is when the recusal was made, the father's counsel said, yes, I agree, essentially saying, yes, I agree with Your Honor's view of the case in those moments. And the judge had said, narrow the issue, whether or not they did services. So at that point in time, father's counsel didn't have any problem with the judge sort of narrowing the scope and describing how she saw the case.
In follow-up to Justice Milkey's question, later on in that same talking about it not being a triable case, she also says, and I'm just not understanding how there isn't a resolution to this case. So she's telling mom and dad, somehow, you should have settled this. You shouldn't have gone to trial. How is a mom and a dad supposed to believe that the person that's hearing this case is a fair and neutral arbiter when she makes that comment? She's already decided it.
It's certainly not an ideal statement to make. However, taken in context, looking at the trial as a whole, especially the judge's comments after mother joined father's motion for recusal on the subsequent day, as well as the judge's actions towards mother and father. An example of which is when mother and father were testifying. They both were very emotional and were struggling at some point, and the judge was compassionate and asked him if they wanted to take a break, encouraged them to take a break and take a moment. So that's one example, again, with the other examples of the judge ruling against the department, ruling in father's favor, mother's favor.
I wanted to follow up on that question, though, because I had the same question. It looks like these comments are tied up in the judge's mind with trying to promote a settlement, I'll just call it, a not going to trial, which I can't understand as being anything other than urging the parents to voluntarily give up their parental rights. Is that fair?
I don't think so. And just for comparison's sake, I want to mention adoption of TIA, and this is one of the cases that appellants rely on fairly significantly. In that case, this court described the judge's efforts or statements basically as an effort to coerce settlements from reluctant parties to make a settlement here. And in that case, this court said that the judge's comments, although troubling, did not require reversal where the evidence substantially supported the judge's findings and conclusions. And so here, even if this court were to find that some of the judge's comments were troubling, the evidence so substantially supports the finding and conclusions. And I think almost the majority of the members on this panel have indicated that or have noted rather that appellants do not contest any of the judge's findings or conclusions as clearly erroneous.
So let me ask you about this, and I believe Justice Wolohojian asked opposing counsel this. If we find that the judge violated mom and dad's due process based on the comments, do you think the remedy is we just look at the evidence that was submitted and say it was sufficient and that's the end of it?
I do think so. And I think looking at adoption of TIA, that's...
What about the credibility determinations now? So we find that the judge prejudged, and I'm not saying we're going to do this, by the way. We find that the judge violated due process. She had already prejudged the case. She shouldn't have done all that. How do we not throw out all her credibility determinations at that point if we say she was erroneous to do that?
That is an excellent question, and I would love to answer it if I can continue on with my time.
Go right ahead.
Unfortunately, I think I have to say it would be part and parcel. That's not a great answer from the appellee's side, but Your Honor does make a really good point, especially if it's part of the judge's observations of the witness are what have gone into that credibility determination. However, the judge did not prejudge this case, and if this court does determine that the comments were ill-advised and did in fact prejudge the case, the evidence substantially supports the findings and therefore no remand or reversal is warranted. Thank you.
And let me see if there are any further questions. No. Thank you. Thank you both. Or thank you all, I should say. And the case is submitted. Oh, I'm so sorry.
It's okay.
We haven't prejudged the case.
We just have an absent-minded panel chief.
I can just sit down. I'm just teasing. Good morning, Your Honors. May it please the Court. Lynn Eisenman on behalf of the child. Your Honors, the child is asking that you affirm the decree terminating mother and father's parental rights. I don't have a whole lot to add to my sister's arguments. I would just say I would agree with her answer to the question of whether this panel would then look at the evidence if Your Honors are inclined to say that this was a violation. And that comes from adoption of TIA, because I think that's fairly similar. The facts and circumstances of this case are fairly similar to that case. And really the evidence can only lead to the result that the judge reached in this case. And it is important to look at the record as a whole, because this was a limited number of comments over...
What's the test that adoption of TIA sets out? In other words, if we were to find that the comments infringed upon a due process right, is it then, is there some kind of prejudice analysis, or is it that there are very few things that are structural error? So they haven't, the mother and father haven't argued structural error. So I've been working on the assumption that there needs to be some connection between the error and the outcome. But does adoption of TIA explain what that connection or test is?
I don't think it really says what the test is, other than, I think that the parents have to show a prejudice, because adoption of TIA then looked at what was the evidence presented in that case, and did the findings that the judge made, were they clearly erroneous? And did they support the ultimate conclusion that the judge reached? And in spite of the comments that the judge made that the panel in TIA found troubling, they still determined that the evidence supported the ultimate conclusion.
Isn't that problematic? I'm going to give you a strange hypothetical
Sure.
based on this case. The judge says right before this second trial starts, I've already heard all the evidence in that first trial. I don't even need to hear any more evidence. But since mom and dad are here, I'll hear it. Would that be problematic?
I think in that case, yes.
Even though she ends up hearing all the evidence, makes the exact same findings she made in this case. I think everybody would agree if she said that and did that, that's clearly a due process violation.
Right.
But under what you just said and what your colleague said, that's irrelevant because the ultimate findings are supportive of the evidence. So where's that line? At what point do you say, oh, violation of due process, we need to just flip it and go back? Or is it due process, we look at whether there's prejudice?
Well, I think because that's such an extreme hypothetical, but I agree, I understand. You know, these were, again, limited comments. Through the part, I guess, about halfway or 3/4 of the way through the trial, looking at the evidence on its face at that time based on what the judge had. And she never said, I'm not going to consider evidence that the parents want to produce. I'm not going, if they want to, there was talk from, I think it was Father's Counsel, about offering an expert, and she never, definitively said, I'm not going to consider that expert. The expert was never presented as a witness. So she never cut off the parents' rights to present their evidence in support of their positions and offer what they wanted to. And she did say, the judge did say, her last statement was that she was going to keep an open mind. Even during closing arguments, when there was an objection because there was an issue about contested testimony, she said, I'm going to go back and listen to that contested testimony before rendering her decision. And the parties came back after the evidence was closed to receive the judge's decision. So I think the judge was clear that she was taking all of that in and considering it all in making her order. Did that answer your question?
As best it could, I think.
Do you agree that due process requires not only that parties receive a fair trial, but that there be an appearance of a fair trial?
Yes.
That both parts of that are
Yes.
important?
Yes. But I think in context of what exactly happened in this case, that in the end, that's what they received. And just to touch briefly, my time is expiring, so I was just going to talk about the
See if
post-adoption
there's
visitation,
any
if you had
further
any questions on that.
We don't have any further questions, and your time is expired.
The rest of my brief, thank you.
Thank you. Thank you all, and the case is submitted. Our final case this morning is case number 2023P0326, CASEY GODZYK versus Bristol County Savings Bank. And is it Attorney Dion?
Yes, Your Honor.
We'll just wait for people to get settled in. Okay, looks like we're ready anytime you are.
Okay, good morning, Your Honors. Attorney Todd Dion, may it please the Court, on behalf of Vincent Carini and CASEY GODZYK, who are the appellants in this case. The material issue in this case is whether or not the appellee failed to strictly comply with the condition precedent notice terms of paragraphs 22 and paragraph 15 of the appellant's mortgage, thereby rendering the foreclosure on the appellant's home void as a matter of law. According to paragraph 22 of the mortgage, the notice must inform the borrower that he or she has a right to reinstate the mortgage after acceleration, and the notice must be sent 30 days prior to acceleration as a condition of paragraph 22 of the mortgage. The material fact at issue is that on February 4th of 2021, which would be Exhibit H of the exhibits, the appellee sent the appellants a paragraph 22 notice that contained the false and potentially deceptive statement that the appellant's right to reinstate the mortgage after acceleration expired 5 days before the foreclosure.
Wait, that's the October 20th?
That is the notice that was sent to my clients on February the 4th, 2021.
Okay, so can we go back one or two letters? Because there have been a lot of letters. I'd like to look at the June 5th, 2019 letter.
Okay.
Okay? This is one of the previous instances of default. If I'm correct, and I hope you'll correct me because I may not be, this is a letter related to the previous default. Okay?
Okay.
So let's look at that letter. I printed it out from the record appendix. It has 3435 written on it, but I didn't write down which volume. Maybe you can help me with that. I don't know. Maybe you remember the language off the top of your head?
I'm assuming that it must have been a 35A notice.
It's a 35A notice.
It's a 35A notice.
It identifies a date of acceleration as being July 8th, 2019. So as far as I can tell, it complies with both paragraph 22 and section 35A.
Okay.
Okay? Are you familiar with the case Bank of New York versus Morin?
It rings a bell, Your Honor.
All right, well, my question is, under Morin, it appears to me that once your clients received this 2019 letter and had been given a date of acceleration for and the loan had been, a mortgage had been accelerated already, that they weren't entitled to Section 35A again within the 3-year period.
Well, 35A says that has to do with the right to cure that is being afforded to my clients
Right.
within either a 3-year period or a 5-year period.
Right.
Regardless of whether that notice is, whether the notice is required, there's nothing in the statute that does away with the right to reinstate after acceleration. The notice says
Well, you got that during the 2019 letter. You get that right once. According to the statute, you get that right once in any given statutory period. Am I correct about that? I'd like to set
that is a
aside, can we
different-
set aside paragraph 22, any rights you may have under the mortgage to the side? Can we set that to the side initially and just focus on the statutory rights?
Okay.
Okay? If I understand the statutory scheme correctly, the borrower is entitled to one statutory right to cure every 3 years, I think it is.
Yes, 3 years or 5
I
years.
think it was amended, 5 years was before, it's 3 years now, I believe.
Okay.
Every 3 years. Am I correct that the statute provides only one opportunity to cure, right to cure, in a given period of time?
Yes, but I would
Okay.
argue.
And your clients, it's undisputed that your clients got that previously, and that we're within that window.
Yes,
So whatever deficiencies there might be in the later notices, they're not under the rubric of a statutory right to cure, right?
well, there are many sections of 35A.
But none of them gives you a second right to cure within that period.
Correct.
Okay.
Yes.
So, so as long as, that's very helpful to me. So as I understand your argument, it's actually about paragraph 22.
Yes. I
Okay,
believe.
so because this second letter, I have a hard time, and Morin says that once you've gotten one and you've gotten the loan has been accelerated once, if you're within that period, section 35A does not apply.
Well, I would say as far as the right to reinstate after acceleration, it still does apply.
For how
Where
long?
in the statute does it say that? Isn't
30
it all wrapped up in the
35A
notice to which you're required?
35A says that the borrower is entitled to a notice and a 90-day right to cure.
Well, but it's,
One-
the notice has to say they have this 90-day right to cure
Yes.
and can cure it all the way up to the foreclosure. But that's all, isn't it? All in what the notice must contain? And isn't it clear here that your client was not entitled to receive that notice because they already got it within the 5-year period?
I think that the right to reinstate after acceleration remains after the loan has been accelerated.
Okay, but are you relying on section 35A for that proposition? Because then I'm going to ask you, I'm going to need you to distinguish Commonwealth versus Morin for me. If you're relying on the statute for that, then how do you distinguish Commonwealth versus Morin? I mean, not Commonwealth, sorry, Bank of New York, Mellon.
For one thing, factually, the appellee sent an additional 35A notice after that notice.
That happened, I believe, in Bank of New York, Mellon and Morin versus Morin.
Well, the notice, it's an additional notice that was sent that contradicts the notice that I'm challenging. And regardless of 35A's requirement of a notice, I still think that under 35A, there is a remaining right to reinstate until any time
Where
before
in the
foreclosure.
language of 35A does it say that? That separate from the notice requirements, a borrower has the ability to cure a default right up to the foreclosure? Because I'm having a hard time
Well,
seeing
the
that.
statute doesn't say that it does not exist.
But it doesn't
It says that it is a right
affirmatively,
to cure, and that is a pre-acceleration requirement. After acceleration, I'm reading the statute as saying they still have. a
Judge
right to
Milkey is
reinstate.
asking you for specific language. So let's look at the statute and perhaps you can give us the specific language that you're relying on in section 35A. Can we
30
do that?
35A says that you have a right to redeem any
We're
time
looking
before
for
the
the
foreclosure.
exact language. So let's turn to the section. Which section are you looking at in
C8.
35A? Which one?
C8,
C8.
I believe it is.
You have it
was
in front of
C8.
you?
I do not have it in front of me, but the right to redeem any time the foreclosure.
Right, sure, but of course, that's a subsection of section C. And C says, "The notice required in subsection B shall inform the mortgager of the following," and then it lists a whole bunch of things. So it's a section that requires what a notice should contain. That was not Judge Milkey's question. Judge Milkey's question was, what in the statute creates a right, the right you claim it does, as opposed to saying what the notice needs to contain?
The notice does not, the statute does not specifically state that.
Okay, so let's,
right to redeem.
so I
Yes,
think
sorry.
where that leaves us in your case is purely paragraph 22.
Yes.
Okay.
Yes.
So, under paragraph 22, the mortgage provided a right to cure and reinstate up to 5 days before the foreclosure sale,
Yes.
right?
Yes.
And you got that, your clients got that. So, where are we?
It's not, well, the notification of the 5-day deadline is not a requirement of paragraph 22 of the mortgage.
Was it 19?
Paragraph 19 explains the conditions required to reinstate the mortgage.
Right, so, and that gives the 5 days. So,
Yes.
paragraph 19 was satisfied here.
They got 5 days, right?
They got their 5 days.
Well, they were not, my clients were not notified of a reinstatement figure until 2 days before the foreclosure. So I would say
I thought the
no.
notice told them, let's
The
look.
notice told them that they can reinstate up until 5 days before the foreclosure.
Didn't it give them the deficiency amount there in that same letter?
No.
Oh,
Well, not a reinstatement amount. They give them a cure amount.
okay, why aren't those the same?
The cure as opposed to reinstatement, cure does not include, if you look at paragraph 19, the many additional fees that they are allowed to charge when the notice has been accelerated. There's a major difference between pre-acceleration and post-acceleration, and there's a number of charges and fees that may be charged as part of a reinstatement figure.
Can we look at the letter that was actually sent? Which page are you going to refer me to?
The letter was Exhibit H.
That you're saying is not enough?
The letter that I'm challenging
H?
is the Exhibit H, the letter that was sent on February the 4th, 2021.
And your argument depends on that figure given in there is merely a number for curing but not reinstatement?
Correct, yes.
All right, was there evidence in the summary judgment record on that point?
I believe it's in the letter, the cure amount. And then later on, 2 days before the foreclosure, there was a reinstatement figure provided to my client. And that was within the 5 days.
All right, the letter says, do you have the letter in front of you?
I had just looked at it, but no, I do not.
Okay, you are in default. In order to cure this default and return to your regular monthly payment, isn't that a way of saying reinstating?
No, reinstating is completely different than reinstating after the loan has already been accelerated and the loan is all of the amounts due under the mortgage are due.
Right.
And reinstating would be paying all of the fees and expenses and foreclosure fees that or late fees. I'm sorry.
Can I just ask the question in a slightly different way? If 35A did not exist, didn't they satisfy their obligations under the mortgage, under paragraphs 22 and I think it's 19, reading them together? Again, assume 35A did not exist.
35A does not exist. The notice was contrary to the previous notice that they sent.
Yes, please answer my
Yes.
question. If 35A did not exist, didn't
35A
they?
doesn't exist, then yes.
Okay, so why isn't there a different result if 35A exists, but it doesn't apply because they already had their one bite at the 35A apple?
Because they had sent a previous notice notifying them that they could cure or reinstate any time before the foreclosure. And I think that the notice prior to the acceleration is the operative notice, and that's the notice that really matters, the last notice before.
Is this the February 4th notice?
Yes, that is the last notice given prior to the condition precedent acceleration and foreclosure,
The loan had been accelerated before in 2019,
and that was cured.
but it had
Was
been
reinstated.
accelerated. I think we're just going around in circles at this point. Let me see if there are any further questions. Okay, thank you. Your time has expired.
Good morning.
Is it Attorney Force? No.
No, Your Honor. My name, and may it please the court, my name is Jeffrey Milsom, and I represent Bristol County Savings Bank.
Okay, that is not on our slip. Milsom?
Milsom, M-I-L-L-S-O-M.
Okay, thank you.
Thank you. On behalf of Bristol County Savings Bank, I believe this presents a refreshingly straightforward and narrow legal issue in what is a very complicated and at sometimes conflicting area of the law. As Your Honor recognized in questioning appellant, the appellants in this case had redeemed their mortgage, had cured a default, redeemed a mortgage, brought it back from acceleration in the 3 years prior to their default in 2020. There are so when they found themselves in default in 2020, they had a right to cure. There are two potential sources of that right. One is the statute, Section 35A, and the other is the contract. The statute didn't apply, and the rights to accelerate conflict. The statute says the appellants may, or any borrower may, cure their default and redeem their mortgage up to the moment of the foreclosure sale, essentially.
Right, so if the statute applies, this February 4th, 2021 notice is not correct. But your argument is that the statute doesn't apply.
That is correct.
And why is that?
Because of the prior redemption in 2019.
And where do you, and so what's your authority for that proposition?
It's the language of Section 35A itself, which requires.
Because if you only get one right to cure in a period, then it means that if you get a second right to cure, it's sort of extra. The bank did it, but the only obligations the bank then has to extend are that it comply with the terms of the mortgage.
Well, yes, but with a caveat, the borrower always gets a right to cure. There's always a right to cure. I think the right to cure probably pre-existed the statute because it's contractual in nature as well. So the question really is, at what point in time is the right to cure cut off? And under.
Are you talking about, I thought you just said something I was trying to say. Are you talking about the statutory right to cure or another right to cure?
Well, there are two sources. There is a right to cure. There is a right to cure emanating from the statute, and there is a right to cure that emanates from the contract itself. It's essentially the same right. It's a right to cure.
Well, it's
However,
a little bit different.
Yes, it is.
Okay, because the mortgage doesn't say you can only cure once every 3 years or 5 years, and it only allows a cure up to 5 days before the auction, whereas Section 35A gives you a right to cure, statutory right to cure, every 3 years, and that provides that you can cure up until the date of the auction.
That's correct.
Am I correct?
Yes.
Okay. I believe, and correct me if I'm wrong, you're arguing that the only right to cure that applied to these borrowers in 2021 were their rights under the mortgage.
That is correct, Your Honor.
Okay. And the reason for that is, I take it, that they'd already gotten one bite at the apple under Section 35 or A, or multiple bites at the apple under Section 35A during the window that's provided in the statute.
Yes, correct.
Okay. Are you familiar with the case Bank of New York Mellon versus Morin?
I've read it, and I'm familiar from your argument, from the argument preceding mine.
Okay. Do you think it has any bearing on this case?
As I understand it, yes. As you've described it, it cuts off the statutory right to cure and more importantly, the right to cure up until the moment of the foreclosure sale. If after that right is exercised one time in the proceeding, I think then it was 5-year period, now it may be a 3-year period. So yes, I believe it not only is relevant, I believe it's controlling and dispositive of the issues on this appeal.
Now, I'm looking at the Thompson case, which includes the statement that the 5-day limitation period, quote, is superseded by the more generous reinstatement time period specified in the statutory scheme. I assume what you're arguing is that statement can't be taken out of context, that this applies when 35A is applicable, and it wasn't applicable in this case, and therefore, don't overread what the SJC was saying in that case.
Precisely, Your Honor. That is precisely our position.
Do you have anything further to add other than what's in your brief?
No, absent additional questions, we will rest on our brief. Thank you very much.
Let me check for questions. No? Okay, thank you both. The case is submitted. And with that, I'd like to thank our court personnel for their help today and assistance, and the court is in recess.